Right, so good evening everyone and welcome to the first of our two seminars on the Corporate Insolvency and Governance Bill. My name is James Morgan QC and I'm co-hosting with Chris Boardman QC.
Good evening everyone.
Those of you who have looked at the bill will have seen it runs to a formidable 238 pages. It's perhaps limited consolation if you remove the pages associated with Northern Ireland and Scotland, it's only 155 pages. There are, in the modern way, lengthy explanatory notes, which are to be found in a separate 64-page document. Only this week, the government has published on the gov.uk website further informal guidance and practical examples as to how the bill will work. There is plenty to be read. It is, of course, presently only a bill, and changes are possible as it goes through Parliament under the fast-track process. We do not know precisely when it will come into force, but it had its second and third readings yesterday in the Commons, which produced at least one significant amendment for tonight's purposes, and the working assumption is that it will come into force shortly this month. According to the explanatory notes, the bill is intended to provide flexibility and breathing space for companies during what is described as, perhaps with something of a danger of understatement, this difficult time. It's expressly stated in the notes that the policy is to ensure that businesses can maximise the chances of survival, which may be something that informs the interpretation of the bill when it becomes law. Now, the bill contains a mixture of permanent and temporary measures, and tonight we're going to focus on what we think are the most significant permanent measures, the moratorium and the restructuring plan. To make things more complicated, there are some temporary provisions in relation to the moratorium. In next week's seminar, we will be covering the other permanent measure, which is the protection of supplies, and also the temporary measures in relation to winding up petitions and wrongful trading. Both the moratorium and the restructuring plan have been the subject of previous consultation by the government. It was unclear when, if at all, they would be made into law. It appears that COVID-19 has, as in so many other aspects of life, accelerated events. Whether they are being rushed, we perhaps leave you to judge. Now, you will hopefully this afternoon receive by email PowerPoint slides. We're not going to share them on screen, but please look at those separately if you think you would find that helpful. So the format of the seminar is as follows. It's going to be two short presentations by Kate Rogers and Adam Deacock on the moratorium. Chris will then lead a Q&A on that subject, followed by a poll. We have some advanced questions. Thank you to those who have sent those in, but there is a Q&A button on the bottom. So if you want to send some questions in as we go along, please do so. After that, there'll then be two slightly shorter presentations by Andrew Brown and Tina Kyriakides on the restructuring plan. I'll then lead a Q&A on that, followed by a poll. Again, send in questions if you'd like to. There'll then be a wrap up by Chris at the end. So without further ado, I'm going to hand over to Kate to kick off in relation to the moratorium.
Thank you, James. So I'm just going to spend a few minutes giving a broad overview of the new moratorium. As you will all probably be aware by now, there is going to be this new freestanding moratorium to give, as James just described it, some breathing space to companies within which to try and rescue as a going concern. We will find this new moratorium, it has its home in a new Part A1 to our Insolvency Act, of course replacing the current and very scarcely used moratorium that we currently find in Part A1 of the Insolvency Act. So I'm going to just touch on 6 key points in respect of the moratorium that are covered by the bill. Those are the way in which a company can obtain a moratorium, period of the moratorium, including extensions, effect of the moratorium, provisions concerning the monitor and provisions concerning offences, and then finally I'm just going to look at the super priority of moratorium debts going forward in a further administration or liquidation within 12 weeks of the moratorium. So first, to begin with obtaining the moratorium and the documents that must be filed. So where the company is an eligible company, and you'll find that there's going to be a new schedule, a ZA1 schedule, where you'll find details of an eligible company, then a moratorium may be obtained simply by the directors filing with the court a certain set of documents. Now they're all detailed at A6 of the bill, and they're listed on the handout that was sent to you earlier with the slides. I won't read them all out now, but save it just to say that you need 2 statements from the directors and 3 statements from the monitor or monitors if there's more than one. And importantly, that includes a statement that, in the monitor's view, the company is capable of being rescued as a going concern, or likely to be rescued as a going concern. However, if there is an outstanding winding up petition against the company, the directors need to apply to court. You can't simply file the documents, you must apply for a moratorium. I pause there to say you'll hear the seminar next week that will tell you actually during this temporary period where we're subject to the temporary provisions for coronavirus, that's not the case. But dealing here with how things will look in the long term, ordinarily, if there's going to be, if a company with a winding up petition against it wishes to apply for moratorium, it's by way of court order. Just 2 brief points to make about that. First, you need to file all the same documents as you would do if you didn't need a court order. And secondly, that in the court's discretion, if deciding to order a moratorium, the court may only do so if satisfied there would likely be a better result for the company's creditors than if the company were wound up. Obviously, the slight anomaly there is that in filing your documents, you're filing a statement from the monitor saying it's likely that the company is going to be rescued as a going concern. So slight anomaly there, and presumably if it's going to be rescued as a going concern, then it would always be better for the company's creditors. But as James said, this is only a bill, so maybe we'll see that ironed out in due course. Secondly, period of the moratorium. So the moratorium will last for an initial period of 20 business days, but as was just referred to in the introduction, there has been one amendment come out of the second and third readings, which were read in House of Commons yesterday, and it appears that as a result of that, there's going to be an amendment such that for small businesses, there will be an initial period of 30 business days for the moratorium. Now, we were debating it between the speakers a little earlier, and we're not sure where to find the definition of a small business, so that waits to be seen. But it seems there may be a distinction between small businesses and otherwise in terms of the initial period of any moratorium. Following the initial period, the moratorium, once the moratorium has been in place for at least 15 days, then an extension can be sought for a period of further 20 business days without any creditor consent, simply by applying to court. However, with creditor consent or a court order, the moratorium can be extended for a period up to a year from the date of its commencement. 2 final points in respect to the period. Firstly, if a CBA is proposed, then the moratorium will not end until that proposal is disposed of. And secondly, if the company enters another insolvency process, such of course as administration or liquidation, the moratorium will naturally come to an end. But that also applies to if the company enters a restructuring plan, the moratorium will be brought to an end. So the effect of the moratorium. Well, importantly, for today's purposes, the company is entitled to a payment holiday in respect to pre-moratorium debts, which might leave you asking what exactly is the company entitled to a payment holiday from? Well, all debts that have fallen due before the moratorium or falling due during the moratorium, except some key exceptions. Monitors' remuneration and expenses, goods and services supplied during the moratorium, rent for the period during the moratorium, wages and salary for employees, redundancy payments, debts and liabilities for financial services. So therefore the company needs enough cash to keep trading through this moratorium. Except in very limited circumstances, no insolvency proceedings to be expected. Of course, the main exception to that is the directors themselves applying for administration or liquidation. Without leave of the court, no steps taken to enforce security over company property. No proceedings commenced or continued against the company during the moratorium, save for some exceptions such as employment tribunal. Moratorium prevents a floating charge from crystallising. And finally, there's various other restrictions on the company's property and transactions during that period, such as the company can't obtain credit of more than £500 unless the creditor is specifically told that there is a moratorium in place. So moving on from the effects of the moratorium, just going to touch on a very few key points about the monitor, which I know will be of interest to many of you listening today. So the monitor, of course, is to oversee the moratorium, whilst the directors actually remain in control of the company. The monitor needs to carry out sufficient supervision such that the monitor can satisfy themselves the company remains likely to be rescued as a going concern. But important to point out here that the monitor is entitled to rely on information received from directors, unless, of course, there's any reason to doubt the accuracy of it. Monitor may apply for directions. Monitor must bring the moratorium to an end in certain circumstances. For example, no longer possible to rescue as a going concern. And then finally on this, an important point, monitor's actions or omissions may be challenged by a creditor or any other person affected by the moratorium. Basis for challenge being that any act, omission or decision of the monitor during the moratorium has unfairly harmed the applicant or has unfairly harmed the interests of creditors or members. So we'll have to wait and see how the courts interpret unfairly harmed. It sounds relatively stringent, but we'll have to wait and see on that. Moratorium offences. Officers of the company commit offences in certain specified circumstances. Two key points. Firstly, if the officer of the company commits fraud or fraudulent representation used to obtain a moratorium or obtain an extension, the more relevant there will be the extension because, of course, a monitor has a lot of input in obtaining a moratorium in the first place. Directors are responsible for extensions. Secondly, an offence is committed in respect of a whole list of different circumstances that are identified within the bill, all surrounding concealing with, parting, disposing, hiding company property. So as we would expect, effectively removing or concealing company property. So finally, just the last point to make in respect to moratoriums is to touch on the super priority. Now, the debts, moratorium debts, or pre-moratorium debts that were not subject to a payment holiday, i.e. what we mean by that is just anything that should have been paid during the period of the moratorium that was not paid, will be subject to a super priority in a subsequent administration or liquidation if that is commenced with, or the petition's filed, or the administration order is applied for within 12 weeks of the end of the moratorium. And that super priority gives priority ahead of preferential creditors and floating charges. So where do we find that provision? That's in Schedule 3 of the bill. And effectively, we start with Schedule 3, paragraph 13, which gives a new section 174A into the Insolvency Act, providing that where a company is wound up within 12 weeks of the end of the moratorium, then anything should have been paid that wasn't paid during the moratorium is paid in preference to all other claims, it's the wording, i.e. ahead of preferential creditors. And then Schedule 3, paragraph 31 deals with exactly the same in respect of administration, where the bill makes an amendment to Schedule B1 of the Insolvency Act by inserting a new paragraph 64A. And 64A simply does as with section 174A, provides that moratorium debts rank above all other claims and expenses other than fixed charges when a company enters administration within 12 weeks of a moratorium, and that specifically includes floating charges by reference to it. So that is a extremely fast whistle-stop tour of some of the key points of the moratorium, and I'll hand over to Adam to look at it in a little bit more detail.
Thanks, Kate. Right, so thanks, Kate, for giving that overview. Now, I'm going to address you just on this question of how the moratorium might compare with administration and some specific problems. We haven't got terribly long, so forgive me if this is a little bit of a whistle-stop tour. So now the first point that arises is you might actually regard, in some respects, the moratorium as being what administration was originally intended to be, but perhaps wasn't. If you consider administration, it can have a number of purposes, only one of which is rescuing the company as a going concern. And as I think we probably are all aware, the tendency has been that perhaps that first possible objective is not very often achieved, and more often it's for achieving a better result than would be likely in a winding up, or just simply realising assets for creditors. In contrast, the moratorium can only be for the rescue of the company as a going concern. And it seems likely that, bearing in mind that the monitor will have to certify that it is likely that that will be achieved, the monitor might have to think much more carefully about that than a proposed administrator might do, who might simply think this was one of the possible objectives, and that as long as one of the three are obtained, that would be enough. But you're really going to have to think, if you're going to be a monitor, specifically of whether you think it's likely that it really will be rescued. So this really is about the rescue culture, which we've heard so much about but rarely seen. The second really striking difference between administration and this moratorium is that the monitor is a very different sort of office holder. In fact, I think there might be an initial tendency to think that being a monitor is yet another IP appointment, but in many respects it isn't really at all. An administrator, as we know, is a person appointed to manage the company's affairs, business and property. But in fact, under the moratorium, the monitor is not that person. That's going to be done by the directors. The monitor is merely a person who has the functions of a monitor, in the words of section A52, which aren't particularly illuminating. Secondly, now an administrator has to get into their hands all of the property which they think the company is entitled to. And a monitor will not get their hands on anything really, other than potentially some information which they will use to monitor. The monitor will simply have a series of ad hoc powers, duties and functions, which we can only find by running the whole way through the section. But broadly, these are the functions of certifying that it is reasonably likely that the company will in fact be rescued, and that the company is going to be able to pay the debts that it has to pay, which we'll get onto a little bit later on. Apart from that, the monitor has to tell people that there is a moratorium, tell the creditors that, tell the creditors when there's an extension, and the monitor has a function because they have to be asked to consent as to whether or not a security should be granted, or property perhaps can be disposed of, or in fact that certain debts can be paid. But subject to that, the monitor does not have extensive general powers in the way that an administrator does. This, of course, is what really creates a hazard, which I think we might return to later on, as to whether or not the monitor really has responsibility but not power. Now, a third point, which it really leaps off the page at you, is that administration lasts potentially for a very long time. Even in its initial period, it'll last for a year. And of course, it's extendable by the court. As we all know, it's extendable by consent for at least one more year from the creditors. So administrations can and often do last for many years. Now, in contrast, as Kate has already referred to, a moratorium seems to be, at least initially, a remarkably short process. In the first instance, it lasts 20 business days, or I guess 4 weeks excluding bank holidays, or 30 in relation to something called a small business, which appears to be completely undefined, but was recently introduced by amendment. But even 30 days is not really very long. And it's extendable with creditor consent, without creditor consent, for 20 business days. But even that extension requires the monitor to certify, obviously, that it's likely to be rescued still. But secondly, the directors will have to certify that they have, not will, but have paid all the debts that have to be paid as well. So they're on a very tight leash. As I understand it, they're not allowed to apply for some time for an extension. And those of us who are familiar with the lightning fast pace of the business and property courts will know that it raises interesting question as to how we're going to get on really very quick applications, which will be required in the event you need to go to court to extend. Because one of the things we know from the Act is that you cannot extend a moratorium once it's already expired. So it's likely that there may have to be some quite urgent applications. And in any event, things are going to have to be done very quickly. Now, James mentioned in the overview that the purpose of a moratorium is to give a breathing space. It's not a very long breathing space, although obviously it could be extended for up to a year. You're on a fairly tight leash, and basically if the creditors aren't going to want to consent, you're going to have difficulties. So really a moratorium seems likely to be a breathing space that will not last for very long, and this raises a question of how useful it might be. Now, the next point, which I think perhaps in a comparison with administration is quite important, is, well, looking at who has to be paid. In an administration, it doesn't really say anywhere you have to pay X and you have to pay Y, but what it does say is that there will be certain debts arising out of contracts entered into an administrator that have priority, and administrators will generally want to pay the trading debts as and when they go along. Subject to that, there is this moratorium on the enforcement of liabilities, which will prevent anyone from taking action against the company without the consent of the court or, of course, the administrator. Now, by contrast, in a moratorium, there is the specific provision requires the company both to pay moratorium debts, which are ones, I guess, which have been incurred during the course under contracts entered into during the course of the moratorium, but also pre-moratorium debts where the company doesn't have a payment holiday. And these are quite extensive and themselves are likely to cause some difficulties and restrictions on the usefulness of the procedure. I'll get onto that in a moment. But in addition, there is this peculiarity that in a moratorium, there is actually a restriction saying that you're not allowed to pay pre-moratorium creditors more than a specified maximum. That's the ones where you do have a payment holiday, more than a specified maximum unless the monitor consents. All of these questions, though, nevertheless, are in the hands of the directors, subject to that consent from the monitor. Now, going into this into a little bit more detail, in an administration, there's quite a lot of elbow room as to whether the administrator is going to pay debts. They might want to do so by the end of the administration. They don't necessarily do it immediately. They can take advantage of the fact that there's a moratorium. Of course, there is some statutory charge priority given, but the administrator have a little bit of elbow room. The administrators can decide not to fulfill a contract because it's not of any use to them. And they can decide if they want to use specific property, they may have to pay the rent for it. Now, because of the way that the non-payment holiday debts are defined, there is no such discretion. You have to pay the rent for all properties that the company rents, whether you want to use them for the moratorium or not, during the moratorium. You don't have to pay the pre-moratorium amounts, but you will have to continue to pay during the moratorium. You have to pay for goods and services supplied during the moratorium, even if you don't want them. You don't really have a right, as I said, as an administrator does, to simply break some of these contracts. And it's not dependent on whether these are specifically used for the purpose of the moratorium. You've got to pay for them. And most crucially, you have to pay any debts arising under contracts for financial services. And that's very broadly defined and actually seems to include basically loans. So the moratorium provides no protection and a positive requirement to pay the finance liabilities of the company. It only really provides you with a breathing space against the evil trade creditors who might be pressing for you. Now, the last point I wanted to touch on, as I said, unfortunately, you don't have terribly long to deal with all this, is this question of super priority. Is there really a difference from administration? Now, administrator has these broad powers, which include a power to borrow and to grant security. And if they do that, those debts will be payable ahead of of a floating charge, for example. So, to that extent, it's fair to say the administrator can do this. Now, under a moratorium, there is no specific provision. It was originally intended that there might be debtor in possession financing, but that hasn't come out as the Act was eventually drawn up. Now, there is a strange anomaly, which is the directors can only grant security if the monitor consents, but on the other hand, they can take out unsecured loans and they don't require the consent of the monitor. The monitor really has very little power to prevent that from happening. But of course, if they do take out those loans and they fall due during the moratorium, then they will have to be paid. Now, the anomaly, which I think has been touched on before, is this peculiarity that if you incur a moratorium debt and you subsequently go into administration or winding up, then it seems as though the moratorium debt will enjoy some form of priority in that it will actually come out ahead of everything apart from the official receiver's expenses and a fixed charge. And it appears that it'll come out ahead of an existing floating charge. Now, this is something which it seems to me if you were an existing floating charge holder, you might take considerable exception to. And therefore something we might watch out for. Now, hopefully the regime will not allow the directors to do anything naughty, and there are of course criminal offences involved, but experience suggests that there may be some jiggery-pokery involved in transactions that take place during the course of the moratorium. Anyway, that's as far as I can take you on this whistle-stop tour, and I think Chris would like to consider whether there are any questions from the audience.
Thank you very much, Adam, and thank you, Kate, as well. James and I have been doing our best to answer the questions as they've been coming in during the course of your presentations, and some very astute questions have come in, and some less astute ones, as you would expect. What I've done is I've prepared some questions which, quite a few questions came in actually before the seminar. And I've been asked to read them out. So what I'm going to do is I'm going to ask either Kate or Adam to lead on those. And I'm going to introduce and read out the questions myself. Depending on how things go, James will do the same or read out questions that you have been asking during the course of the seminar. Okay, so question one, and this is a strikingly similar question was asked, in fact, by Eileen Blackburn of French Duncan and also by Anthony Fanshawe of FPN Limited. And the question is this, and Adam, I'd like you to lead on this if you would. What arrangements will IPs be expected to make for the board to report key financial numbers within the time constraints of the moratorium? Adam.
Right. Well, that's a very interesting question. It strikes me as being the sort of issue which is more likely within the expertise of insolvency practitioners themselves rather than lawyers. But in general terms, it seems as though the answer, in a sense, is supplied by what the monitor is supposed to do. The monitor has an obligation to, under Section A35, to monitor the company's affairs for the purpose of forming a view as to whether it remains likely the moratorium will result in the rescue as a going concern. Now, frankly, what information that will actually require will depend on the circumstances of the case. In the guidance notes, the Insolvency Service, I think, provided a sort of worked example in which it suggests that you might have a moratorium because something simply requires the directors to take out finance, borrowing on their own houses in order to pay off the debtors, the creditors. And that would only require a very short period. Now, in a situation like that, it seems to me the information that's required would simply be information to indicate that the financial position hadn't got any worse and that the directors were actually going to borrow the money. Given that this is supposed to be such a short breather position, it seems unlikely, one would think, that it will be suitable if it involves a really major restructuring. It seems to be more suitable for, as we were told, a sort of a breather. So quite what information that will require, as I said, sorry, ducking the question, depend on the particular circumstances of the case. It's also worth bearing in mind that the monitor, although the monitor isn't told to monitor anything else, the functions imply that the monitor would also have to monitor the question of whether the company is paying its moratorium debts and pre-moratorium debts, because Section A38 tells us that the monitor has to bring the moratorium to an end if they're not doing that. And that obviously implies that the monitor has to be on top of the question of whether that is happening. But I would have thought that in that situation, you'd simply need to have an understanding of all the debts which are relevant and which are going to fall due in the relevant period, and a sort of cash flow statement in the first instance, and a proof that you've actually paid as you're going along. I hope that isn't ducking the question too much.
Adam, yes, thanks for that. And actually, in this question, I thought it identified an interesting tension in the bill between the need for speed, and in particular, both in the period leading up to the commencement of the moratorium, and actually the period of the moratorium itself, which is relatively short, and at the same time, the need for the monitor to have enough information to effectively back, either by way of approving, by signing its consent to act, or by agreeing to an extension, or indeed by continuing the moratorium. And that it seems to me there's a tension between those two things. It's a tension which, for those of you who have spent some of today reading the exchanges in the House of Commons yesterday, it seems some of the MPs were alive to. For example, Stuart Hammond, Wimbledon MP, said that he thought that normally a huge amount of due diligence would be required on a company's finances and creditor arrangements in order to come to a view that the company would be likely to survive. And it seems to me that the difficulty here is caused by the test being at a relatively high level, namely likely to be rescued as opposed to simply reasonably likely, which is the administration test. So on that basis, you'd need more information to have a sort of higher level of confidence in the outcome of the company. And Jonathan Jangley was complaining about the lack of time to debate in the Commons yesterday, because what he described as what was supposed to be as an oven-ready process, which was a very topical phrase, he said might not work if the IPs and the courts did not know what it was that they were supposed to be doing. And it seemed to me that he identified a real issue for IPs at the moment, is that unless they're sure what actually they need to be satisfied, and obviously, as Adam rightly says, that will depend on the particular case, but unless they can be satisfied that they've got the right information, then can they back it? This is a dilemma which all of us are going to be coming to grips with over the next few weeks and months, no doubt. Anyway, I think we should move on to another question now. This question, again, I'm going to read it out, is from Paul Brindley of Midlands Business Recovery. And Kate, I'd like you to lead on this if you would. The question is this: if the IP has no real powers and no money, but is the person who liaises with creditors, and it is he or she that the creditors will hold accountable and expect answers from, why should any IP take on the role as monitor?
Yeah, this is something that's come up a couple of times as to what is really the benefit, what's in it here for the monitor. Well, I think a couple of things I'd say on that, but before we get to that, it's important to remember that though there are all these obligations on the monitor and they can be held accountable, a monitor is entitled to rely on information and documentation given by the directors, unless there is any reason to doubt its accuracy. You can simply rely on what you're being told. And in respect of the provisions dealing with any challenge to the monitor, it's set out that a monitor can't be ordered to pay compensation under that part. So it is specified to that part, but there is perhaps some level of protection there to hopefully reassure to some extent those who are considering taking the role of a monitor. But two matters we've identified as potential benefits here. It is quite possible that a moratorium is going to be a precursor in the end to what actually ends up being an administration or a liquidation. And in that situation, there was, when this was initially proposed, a ban on the monitor acting or being appointed in a later administration or liquidation. And now that ban has specifically been removed. So it's obviously within the mind that the monitor can go on to become, for example, the administrator. So it may be a lead into a subsequent bigger job. And secondly, of course, fees are payable on a contractual basis with the company. It's not a case of waiting to be paid out of realisations. So as long as the company's got sufficient assets to pay you and its other moratorium debts, then fees should be hopefully pretty swift and on a contractual basis. I think that's probably the two best points that I can think of, unless Adam has some more.
Not on this particular. I understand there might be another similar question, or we.
Yeah, I might just say this. I thought this was an interesting question because it particularly brought out the possible questions of whether or not a monitor would have any dealings with creditors, or whether he should sit behind the directors and just leave the directors to deal with outsiders in the company. I mean, on the face of it, the monitor doesn't have the status of agency like an administrator. He's simply an officer of the court. And on the face of it, his only direct duty, as Kate explained, is to ensure that the likelihood of survival is in place. So that's it. But the reality, I think, is going to be different. And I think this is why the question is interesting. The reality is that in order to satisfy himself that recovery is going to take place, the IP may well have to communicate with creditors. In fact, in the government's consultation before the bill, the government very much indicated that the level of the threshold was such that there might be, even before the moratorium came into place, communications between the monitor and various creditors to ascertain whether or not this thing was a runner at all. And I think that this creates a sort of, well, one, a dilemma for the monitor, but also a trap potentially, because a monitor won't want to, and should take care not to become too enmeshed in the company's affairs, and possibly thereby either become an agent for the company or indeed assume responsibility towards any creditor. So I think this is a real issue for monitors going forward. It's something that they're going to need to take care not to get too involved in. But yes, Adam, you mentioned that there was a follow-up question. There was a similar question from John Cooper of the Wilkes Partnership, which brought out a slightly different point, which is the distinction between this type of moratorium and indeed the previous moratorium. So I'll read that out, Adam, for everyone's benefit, and then Adam, if you could address that. The question is this: previously, CBAs with moratorium were unpopular with IPs, largely because of the uncertainty regarding the extent of their required monitoring or policing duties and obligations, combined with the potential liability or sanctions for any breach. The new statutory moratorium also requires IPs to carry out such monitoring, policing duties and obligations. But will the new regime avoid or mitigate IPs' previous fears regarding taking on such functions? Adam, do you want to address that?
Well, yes, I mean, having said that one was comparing this regime with administration, of course, there is the sort of elephant in the room about this, which is that there was a previous procedure under the Insolvency Act 2000. And funnily enough, I remember giving a talk about it in 2000, and the prediction was that it was going to be an abject failure, and it was. That it was felt that nobody would want to take the role that appeared for that particular moratorium because it involved this responsibility and liability, but no power. Why should it be any different this time? Well, the regimes aren't identical. I think the other regime only applied to small companies, if I remember rightly. I say remember rightly because I've never actually come across one of them because they never seem to happen. But there certainly was very little enthusiasm for it, and most IPs thought they might as well just do an administration. Now, why would anyone want to take out this particular regime? Well, I suppose because if they don't do it, someone else will. We have apparently a new rescue culture. If we take it seriously, there may be a new mood abroad. And if companies want to get this breathing space so that they can be rescued, I guess that IPs will want to take the monitoring job. Otherwise, another IP may be prepared to take the monitoring job, and there's no reason why you can't charge fees for it. Now, is there really this big risk of liability? I've been thinking about that. Now, Kate made this very good point that under paragraph A42, the only statutory challenge that appears is one which specifically says you can't order the monitor to pay compensation. Now, it does say under this paragraph, which seems to beg the question, well, could you have a liability to pay compensation elsewhere? Obviously, it's impossible to give a definitive view on this, but it had occurred to me that it was fairly similar to the position of a supervisor in a voluntary arrangement. In the case, you will all remember the case of King and Anthony, no doubt, where the court seemed to say that a supervisor, in exercising the functions as supervisor, which is distinct from the functions of a nominee in advance, would not owe a duty of care. And it also occurs to me that if you are going to be a monitor and you're getting paid, you might as well make sure you have a contract which excludes any liability whatsoever. No doubt there will be a friendly lawyer there to help you draft that. Those are really the only thoughts I have. One further thought: might you take the position as monitor as a sort of an antechamber to a better appointment later on? That's always going to be a possibility, but it's worth bearing in mind that sneakily under this act, you might think that when the monitor decides under A38 whether to bring it to an end, that they can then do something further. But of course, there's no power in a monitor to present a winding up petition or a creditor's administration application, as you might think, comparing it to, say, the supervisor of a voluntary arrangement, or indeed an administrator who can put something into liquidation. So the monitor doesn't themselves have a power to appoint themselves as administrator or liquidator at the moment. So it's worth bearing that in mind.
Okay, Adam, thank you very much indeed. And whilst we have a lot of questions on this topic, predictably, unfortunately, we've run out of time to go through anymore. Thank you very much for everyone who's asked a question. I will try and answer, and I'm sure James will as well, the outstanding questions in the question and answer box on my screen before the end of this session, or at least in short form if I can. But I think we're going to move on now onto the other main topic. And so I think, Andrew, you're going to go first on the new schemes. Yeah.
Yes, I was just being unmuted there for a second, a bit of technical fun. Thanks, Chris, for that. And good evening, everyone. As noted, I'm Andrew Brown, and I've been tasked by the great and good in Chambers with providing an overview to the new restructuring tool being introduced by the Corporate Insolvency and Governance Bill. Now, I had originally intended to describe this as a whistle-stop tour. Adam and Kate have now stolen what I thought was a unique term, and so I'll describe this rather as a deep, probing, and insightful 5-minute discussion of what is a rather complex series of provisions. After me, the estimable Tina Kyriakides will follow with a much more interesting discussion as to the basis for the cross-class cram-down and other elements. So in short, what the bill seeks to do is to introduce a series of new sections to the Companies Act, which are getting jammed in at section 901A and afterwards, which the eagle-eyed amongst you will recognize immediately follows those sections which deal with schemes of arrangement. This is no accident, as the restructuring tool follows closely on from what schemes of arrangement are and seeks to bring them firmly within the ambit of insolvency proceedings. So now we'll continue on with our deep and probing insight here. The regime can be broken down as follows. It's only available initially when 2 gateway conditions are met. Condition A is that the company has encountered or is likely to encounter financial difficulties, notice the word financial difficulties there, that are affecting or will or may affect its ability to carry on business as a going concern. In condition B, that a compromise is suggested between creditors or members or any subclass thereof, and the compromise is intended to eliminate, reduce, mitigate, or prevent the effect mentioned above in condition A, which is that the company is going to run into issues with becoming a company going on as a going concern. What immediately follows is similar to the mechanics of a scheme of arrangement. So on such an application being made, the court can order a meeting of creditors or of members. Such an application can be made by the company itself, by any creditor, or by an insolvency office holder who happens to be there, say, an administrator. Any creditor or member who would be affected by the compromise has a right to take part in the meeting, unless the court considers that class has no economic interest in the company. The directors, prior to the meeting, must circulate a statement to all creditors and members explaining the proposed compromise and any interest they have in such. Now, ultimately, if 75% in value of the creditors or class of creditors or members approves the compromise, then the court may sanction the compromise. Now, it's important to note here that it's 75% in value, not 75% in value or number, but purely a value. So any sanctioned compromise is binding on all creditors or class of creditors or members, as the case may be. Now we come to the truly interesting bit, which is getting all of the publicity for all of the exciting insolvency news in the world, the cross-class cram-down. This is introduced at section 901G, which introduces a new element. This is as I noted, the cross-class cram-down, which is referred by some as the CCCD, which is somewhat related to the American Chapter 11 bankruptcy scheme, which Tina will be talking about very shortly. In essence, where a class of creditors or members, for instance, secure creditors, do not vote to the requisite 75% level, then if two further conditions are met, they themselves will be bound by the result regardless of their lack of approval. Condition A is that the relevant class of creditors or members would not be worse off under the compromise than they would under what's defined as the relevant alternative, and this is defined as being what would likely occur if no compromise was approved. And condition B, that the compromise is approved by 75% of a class of creditors or members who would receive payment or have a genuine economic interest in the event of that relevant alternative. So you have to have an interest in what might happen. Now, that essentially brings to an end my incredibly quick discussion of this and leads directly on to Tina's discussion. So I'll leave it at that. Or I'll fill the dead air while Tina gets started.
No, it's all right. I've unmuted. Thank you very much, Andrew. I thought that I would focus on the short time that we have, really on the cross-class cram-down and look at really how the new bill deviates from the government response to cross-class cram-downs, which was in the 2018 consultation on insolvency and corporate governance. And that effectively was the last thing that we heard from the government on the matter. Now, of course, cross-class cram-downs, which are used in Chapter 11 of the US Bankruptcy Code, and indeed in other systems, were suggested in order to overcome the problem which we've encountered in schemes, where one class of creditors or members can effectively scupper a scheme or hold to ransom creditors who want to proceed with the scheme. Now, when the matter was left by the government in its 2018 response, the proposals governing cross-class cram-downs were much nearer to what's in Chapter 11 of the US Bankruptcy Code. Now, under that code, there's what's known as the absolute priority rule. And this, in effect, provides that a dissenting class of creditors must be provided for in full before any junior class can retain any property under a reorganisation plan. So under Chapter 11, if a class of creditors or shareholders vote to reject a plan, the court can only confirm it if, among other things, it's shown that the plan is fair and equitable with respect to the dissenting impaired classes of creditors and shareholders. And what's been held in the US is that the fair and equitable rule means that restructuring plans, and that actually includes any pre-settlement plans, will not be approved by the court if they provide for junior creditors to be paid prior to more senior creditors receiving the full value of their claims. Now, our government believed that really the inflexibility of the absolute priority rule, where the court cannot approve anything that deviates from it, really reduces the chances, at least in some cases, for there to be a successful reorganisation of the debtor. Nevertheless, in the 2018 consultation, it concluded that in relation to the proposed cross-class cram-down principle, that in order to protect creditors, the ordinary order of priority in liquidation administration would apply, and that an absolute priority rule would also be imposed by legislation, providing that a dissenting class of creditors must be satisfied in full before a more junior class was entitled to receive any distribution or keep any interest in full. Before a more junior class was entitled to receive any distribution or keep any interest under the plan. However, in order not to replicate the rigidity of the American system, it intended the legislation to provide for the court to sanction a plan, even if it didn't comply with the absolute priority rule, if it was necessary to achieve the aims of the restructuring and was just and equitable in the circumstances. So if we then move to the bill itself, we see in fact that all of that's in fact been dropped. Now, the reason may lie in the crisis that we find ourselves in, and the belief that the less restrictions that there are governing a restructuring plan and the more flexibility there is, the greater the prospects that the companies might survive by actually using this new tool. Despite this, obviously the government deemed that it is necessary to have safeguards for creditors, and therefore, as Andrew has just said, in order to sanction the plans, the court still got to be satisfied that none of the dissenting creditors as a whole is any worse off under the plan than they would have been in the event of a relevant alternative, and that it's been agreed by 75% of a class of creditors or of members who would receive payment or have a genuine economic interest in the company in the event of the relevant alternative. So it's really going to be for the courts to decide these matters, and the exercise that they're going to have to carry out in this respect is going to be different to the one normally carried out in respect of schemes. So therefore, one can actually see that the imposition of the cross-class cram-down on dissenting classes of creditors and members may very well lead to more contested hearings than we get at the moment with schemes. So one can see that maybe creditors or members may oppose sanction by raising arguments, for example, whether condition A in section 901A is met, and that's the threshold of likelihood of financial difficulties, what indeed the relevant alternative is, and that's something that sometimes in fact is raised in schemes. And that's going to bring into account what value they're likely to receive under the plan and what they would have been likely to receive under a relevant alternative. They also might contend that the assenting class does not have a genuine economic interest and therefore is actually not entitled to vote on the plan at all. And looking at all of this, what you might see is that it might very well involve contested expert valuation evidence. And you can also see how cross-class cram-down might be used by more junior creditors to affect the rights of more senior dissenting classes of creditors. And that may depend on how the courts actually interpret being worse off under a relevant alternative. So for example, if the courts actually interpret that to mean that they will receive the same amount as they would have under a relevant alternative, the plan which junior classes of creditors have accepted, but senior classes of creditors have rejected, might be used to extend, for example, the original maturity date of a loan waive defaults on the loan, and so forth. So of course this will all be subject, regardless in any event, because the court's got a discretion whether or not to sanction the plan, and that will be whether the plan overall is fair and equitable. Thank you.
Thank you, Tina. Thank you, Andrew. As before, we'd had some questions in advance. First question I was going to ask, and I think, Andrew, this might be one for you. To what extent is there any linkage in the bill between the provisions in relation to the moratorium and the arrangements? And in particular, do moratorium creditors qualify to vote as creditors in relation to an arrangement?
Thanks, James. Thank God for questions being sent in advance so I could find the answer to this. You can find the answer to this yourself if you need to. It's section 901H of the proposed amendments to the Companies Act. In essence, what the answer is that where the company has triggered a moratorium under the bill within the preceding 12 weeks of the restructuring plan, then creditors who are owed debts which have arisen during that moratorium and who's owed, and those owed pre-moratorium debts which were not subject to the payment holiday, and this is, Adam was discussing this earlier, such as financial services contracts, they're defined as relevant creditors. And the bill provides that relevant creditors cannot vote with respect to the restructuring plan. So it looks like they can't really take part in it.
Thanks, Andrew, for that technical answer. Thank you, that's really helpful. Another question, a bit more of a sort of a practical one, and perhaps Tina, you want to look at this one. What are the circumstances in which you would advise a client to use the new arrangement procedure rather than a CVA? And to what extent are the additional costs of using the new arrangement procedure likely to be prohibitive for SMEs? So sort of two-part question.
Two different questions.
Yeah.
First of all, as to when you might advise a client to use the plan rather than a CVA, the first obvious one is that with CVAs you can't bind secured creditors unless secured creditors actually consent. Obviously, the advantage of the new restructuring plan is that such creditors can be bound by the plan, provided they're not going to be any worse off than a relevant alternative and assenting classes. There's at least one of them that's got a genuine economic interest. I thought of another reason that you might want to use the plan rather than a CVA is that you might come to the view that overall you're not going to get 75% of all of your unsecured creditors who are going to vote in favour. But if you think about the classes and how the court might do class formation, you might think, well, if we divide it into classes, I know that I'm going to get at least one class that's going to consent, so I have more prospect of getting my plan through. The other thing was that obviously with a CVA you need a supervisor. The thing with plans is that they're very flexible, so you don't need any supervisor to implement the plan. So you may say, well, it's fine, the plan can be handled by directors and it'll be dealt with by them. Or you may say, well, okay, we need some form of supervisor, but we don't want an insolvency practitioner. We can have somebody else who can supervise. So you've got that flexibility. Now, just on that, what's very, very interesting is the Insolvency Service very recently did an impact study on the proposals. And interestingly, they believe that there'll only be a take-up of about 50 to 100 cases a year, and that most of those cases will be cases where companies have gone, would normally do a scheme, that these companies will now go for the new restructuring tool. And the reason is obvious, because under the scheme, you need consent from all classes of creditors. So I thought that was really quite interesting. And also what was very interesting from the impact study, they only think there's going to be a benefit to creditors per annum of between 0 and 8 million. So they take a midway point of about 4 million a year, which is quite conservative. Going then to the issue of costs, are the costs going to be prohibitive? Again, looking at the impact study from the Insolvency Service estimates that the cost of going to court will be about £4,000 per case. And I have to say that I think overall that's a huge, huge underestimate. First of all, it doesn't take into account the costs of preparing the plan, it doesn't take into account the costs of these explanatory statements that have got to be circulated, which, if it's going to be very similar to schemes, and I'm sure it will be, can be very detailed explanations, and obviously you get professionals on board. Even sort of like then going to court, bear in mind, if these are not, these are sort of treated as ex parte applications, so you've got to have full and frank disclosure, which means that your evidence that you're going to put before the court could be potentially quite substantial, both factually and having to deal with the issues that you think that the court's going to have to deal with. So that's going to be issues of jurisdiction. So, you know, objectively, the test of whether you're in financial difficulties, and you effectively, that's going to be believed to going concern problems. So it's dealing with that. If you're a foreign company, your connection with this jurisdiction, and so various things, and obviously class formations and so forth. And also looking at valuation. It's likely there's going to have to be valuation evidence as well. So that's going to be quite substantial. And then if you get anybody opposing, well, obviously that's going to shoot your costs up. So I do think that that really is quite a substantial underestimate. And therefore, when you're looking at SMEs, I think the likelihood is the uptake for SMEs is going to be very, very small, if at all.
And as you indicate, the problem is these are upfront costs, aren't they? Rather than, for example, supervisor fees, which can be spread over the life of the voluntary arrangement. I think, Tina, the point you touched on about classes of creditors has been picked up by Gary Pettit in one of his questions about how classes of creditors are to be determined. I don't think we've got time to answer that, but I think how you categorise people is going to be a real battleground over the coming years as this develops.
Yes, I think the way that they'll categorise them is they'll first of all look at the rights that various classes of creditors will have, because they're looking at similarity under maybe what would be the relevant alternative. Then they have a look at the rights that various creditors are given under the plan. Now, it may be, for example, you can't just class them and say, well, I'll just look at unsecured creditors and they'll be classed into one category. For example, because under the plan, unsecured creditors, you might have different classes that are treated in different ways. So you may say, well, I'll treat my trade creditors in this way, and I'll treat other creditors in a different way, and that will create different classes. So it is kind of looking at various rights and then forming the classes. And that can be quite a difficult process, actually. And the thing is, the problem is, if that's done wrong in the first place, and then some creditor challenges, then it may be that the court doesn't have jurisdiction because there's not been the appropriate consents to sanction the plan later on. So, but interesting question.
Absolutely. Well, we're now 6:05. Chris, do you think time for one more question or a wrap up?
One more question, and I think we really should stop.
Okay, so I think perhaps on the arrangements, Tina or Andrew, don't mind. The test of likely to encounter financial difficulties. Is that balance of probabilities? And is it different from is or is likely to become unable to pay its debts? In 1 minute, I reckon you've got for that one.
Andrew, we'll go to you.
1 minute, 1 minute. Well, this is great. I can fill that 1 minute with waffle as fast as I can. Well, obviously, in my opinion, likely denotes a balance of probabilities, as we've seen elsewhere in other contexts. So I can't see that being otherwise. But what I find to be really interesting here is an American who gets taught in his constitution classes about the elastic clauses of the US Constitution is the term financial difficulties. Because quite specifically, what's not been included in there is the word insolvency, just financial difficulties. Now, in my opinion, that's where you're going to start to see quite a bit of people fighting over what exactly a financial difficulty might be. Is that an immediate issue? Is it a far-flung future issue? Tina and I have had arguments over this, so she is more than welcome to jump in and put her side to this as well. I think I filled that minute.
I'm very happy to jump in, but I can see the time.
I think we probably wrap it up and over to Chris to wrap up the seminar. Thank you both.
Okay, well, thanks very much. Sorry, just check. I've got my mute on. No, it's off. Good. Well, on that point, I think that it's actually something that spans both of the topics that we've been discussing today, and for me raises a central question which remains unanswered, which is this likely test and what is the consequence of the likely test. Andrew's just covered that from the point of view of the schemes. We didn't really get a chance to discuss it much in terms of the moratorium, but that's something which I know already yesterday in Parliament, there was a proposal to reduce the would to a could be rescued, because it seems that, you know, if you're already at the point where you already can show and demonstrate to an IP that if this moratorium of only 20 days takes place and the company will survive, or would survive, then you're already a long way along. And in fact, you probably don't even need the moratorium, which was the original idea, was that it would give a breathing space for directors to think about how they would put in place a rescue plan. But anyway, we haven't got time to discuss this anymore. No doubt the debate on these various issues will go on. And it may even be the case that although there was a committee stage yesterday evening in the House of Commons, so that the bill's gone through the Commons now as in the Lords, maybe that the Lords will consider some more technical amendments as is their way. So I think I'll just wrap up by thanking everyone. First of all, the speakers, Kate, Adam, Andrew, Tina, for your hopefully informative presentations. I hope that that's been of some assistance to you, all the delegates. Thank you, all of you, very large numbers who've come out this evening and listened to this presentation. Thank you, all the questioners. James and I have been busy typing away whilst this thing has been going on, hopefully answering not too dismissively some of your questions. And we probably got half of them wrong, but apologies if we have, but we've done our best in the time available. But thank you very much for your perceptive questions. And indeed, could I invite, as you probably know, this time next week, we've got the second presentation, this time on the supply agreement provisions and the temporary COVID arrangements that are going to be in the bill as well. And could I encourage you to send your questions in advance so that we can construct the seminar in the best way that we can. We haven't got any more time for any more wrap up, so I just want to thank you all for attending. Thank you also Georgina and Stephanie for making this presentation possible. I hope you can join us this time next week. Good evening.